in this situation, I had a client who wrote back and said, okay, this was part of the question that we had before, but I didn't see this part, and I apologize for that. My car is owned by a corporation. If I file bankruptcy individually, do I have to list the car? The answer is yes and no. Yes, you have to list the corporation. And what I do is say the corporation owns these assets and these are the debts of the corporation. Basically, I spell it all out for the trustee so that they realize we're not trying to hide anything. Technically, if the car is titled in the corporation name, do you put that car in your Schedule B personal property? The answer is no, because legally you don't own it, but you do own the stock of the corporation that owns the car. So I hope that clarifies that point. And again, it goes back to what we were talking before about the assets and the liabilities of that corporation. Following up on that, the next question I had was, okay, if I owe a debt and that debt is not personal, do I still list it? Same question, but a little bit different. Let me tell you why. Unless you know 100% certain that that credit card agreement that you signed for your corporation does not include your personal name or your personal liability. If you're 100% certain, then you do not list it in your personal bankruptcy because that debt is owned solely and 100% by the corporation. If you're 1% of you is unsure, then I would say you list it in your personal bankruptcy and say in your schedules, this is a corporate obligation. I'm not 100% sure if I don't have a personal guarantee. Always err on the side of over-disclosing. People get themselves in trouble because they under-disclose. They don't say enough. They don't tell enough. They don't give enough information. And I think that's a huge mistake. If you're not giving the full picture to the bankruptcy trustee, you've got a big problem. Excuse me, folks. So what happens is in this situation, you have a debt. You don't know if it's personal or not. You list that fact that you own the corporation, and you list that debt as a liability of the corporation, but you would also list it on your schedule saying, let's say it's to American Express. American Express card as contingent, and it's a contingent debt, and I would put down the amount of this debt is unknown as to a personal liability because it's a corporate obligation and we don't know if there's any personal guarantee on this or not. Come up with some language like that to let the creditor know that this may be a personal guarantee. If it is, it's included in the bankruptcy. If it's not, and it's purely a business debt, well then that personal bankruptcy is going to have no effect on that debt. Remember what we talked about before. A corporation is a separate legal entity, able to enter into contracts and able to be sued. If you take out the personal liability in the bankruptcy, that corporation now is the sole fish on the hook. You have two fish on the hook. One got away, now they've got one. The corporation can be pursued by the creditor. The creditor can sue that corporation and try to get a judgment. Reality, what are they going to collect? Probably not a whole heck of a lot. But it's always there for them to do, to go after, and if they want to pursue it, they're more than welcome to.